So welcome everyone. Like I mentioned, for a couple of new people that just signed on, this is our quarterly fiduciary training led by Bonnie Trikel with Endeavor Retirement. She has one of her newer colleagues on the call with her today, Nevin Adams, and I'll let them introduce yourselves as much as you would like here in a second, but talk a little bit about this training. One, it is obviously quarterly training to keep you guys, all of our clients up to speed on all things ERISA. But then it is also our clients typically, or sometimes, I'd say rarely, but it does happen, run into some ERISA issues, and Bonnie and team have helped some of our clients out with some of those matters. Today's webinar is kind of a stock webinar that we do every February, which is what does it mean to be a fiduciary? And that's always evolving, as Nevin was just kind of commenting to. It's always evolving. So we always do that in February because that kind of kicks off the year. What does it mean to be a fiduciary? But I asked both Bonnie and she brought Nevin on the call because there's some really groundbreaking lawsuits that have come into on our, in our landscape. It's not directly in the retirement plan space, but here's what I'll tell you: it's more in the employee benefit space. However, it's brought by an attorney, and I won't steal you guys' thunder. I'll let you guys talk about all that. But it's brought to the courts by an attorney that, in my opinion, changed the landscape of our industry on the retirement plan side 20 years ago. And now he's trying to do it on the employee benefit side. And if successful, it will affect our industry too. And I want to talk about that later in the presentation. And I've got some thoughts on that, and then we can maybe have some open dialogue on it. But just to kick it off, Bonnie, I don't know if you want to say a little bit more about Nevin. You know his background and his experience. We've got a person on the call that is probably done as much or more than anyone in our industry to shape it to where we're at today. So it's a treat to have you on the call, Nevin.
Much appreciated, Marco.
Yep.
Well, awesome. Well, good afternoon, everyone. Nice to see many of you for another quarterly fiduciary training. But as Marco mentioned, it's great to have Marco joining us today, and it's also really great to have Nevin Adams. So for those of you who don't know this name, any advisor across the country has become accustomed to reading Nevin's material for the last several years. So Nevin was the Chief Content Officer for the American Retirement Association, and also just someone who anyone from plan sponsors to other service providers, advisors really came to know for the way he covered the ERISA litigation landscape, as well as many other issues and trends that faced our retirement plan space. So we're really excited to have him as part of our team as we continue to keep plan sponsors and advisors up to date and informed on what's happening, and most of all, what's important to you. So there's a lot going on, but we really try to refine it to what's important to you. So happy to have Nevin with us here today. As Marco mentioned, we're going to do what we typically do at the beginning of the year to remind you, hey, who is a fiduciary? How do you become a fiduciary? And so we'll cover a few of those basics just to get that out of the way at the beginning. But there's also been some things that have happened more recently where we think beyond, I'm guessing many of you on the line think about things beyond the retirement plan. Although we look at it as a full-time job, for you, I'm guessing you're thinking, hey, this is like one of many hats I wear throughout the day, the week, the month. You probably also deal with things like your healthcare plan and other benefits that you provide to your employees. So we're going to talk about some of those things and how, while it's awesome that you're doing that, maybe some other tips or traps to think about given some of the lawsuits, as Marco mentioned, that have started to shape that space as well. So that's really the basics of what we're going to cover today is when are you a fiduciary and how does that extend to other benefit plans you may be offering your employees. It reminds me of something my mom, said to me when I was younger, like, what is that saying? No good deed goes unpunished. And some of these lawsuits remind me of that when we talk about the voluntary benefit suits a little bit later on. So it's not to discourage you. It's just to help you think about what's out there and how you can really implement some good tips around it and good governance to do it the right way so that those good deeds won't be punished later. so to speak. So with that, I think we will jump into the content. Again, we might be a bit less slide heavy today and a bit more conversational as we go through some of these things and just start with, the normal around, hey, how does someone become an ERISA fiduciary? We've talked about a few of these slides in prior presentations where we've said, if we really, I know many of you get very bored and go to ERISA late at night and you look at the section 3 where you find, Nevin's laughing, you look at section 3 where you find all those definitions and you see that there are 3 ways that you can become an ERISA fiduciary. One of those ways is how Marco and the team at 2 West becomes an ERISA fiduciary because they give investment advice and they get paid a fee for doing so. And that's one way to become a fiduciary. But there's 2 other ways, and this can come up in the retirement side, but other sides as well, like on the health and benefit side. And it's essentially you're using your brain or your discretion and you're exercising judgment. And that can be as it relates to the plan administration or the decisions over how the plan works or how the money's spent. So again, there's kind of these longer definitions, but the gist is, are you using your brain or your judgment as to how the money gets spent, what service providers are selected, who gets picked to, actually administer the plan, and how the plan actually runs? If you're doing that and you're using your judgment, you're not just an order taker in doing it, then you're probably going to be considered an ERISA fiduciary. One of the things I think trips people up the most is this idea that it's actually a functional test. So if Nevin says, hey, I'm not a fiduciary, but then does all the things that a fiduciary does, is Nevin still a fiduciary? Yes, in fact, he is still a fiduciary. And that gets people tripped up, when they will assign titles of, oh, I'm not fiduciary, but then I go and do all of those things. You are still a fiduciary. So that's just kind of one of the things we try to keep in mind as you're putting together committees, or as you maybe say, oh, we don't operate with a committee structure, our organization is not big enough. You can't out-title fiduciary status or out-committee it, however you want to put it. It is what it is by virtue of what you do. So again, many of you have probably seen this slide before, but it bears a good reminder, which is just kind of some of the practical of what does that actually look like in the day-to-day. So when we think about the business owner who's selecting the record keeper, or when you go to select 2 West as your advisor, and then your ongoing monitoring of them, that is going to be a fiduciary activity. So you must do that with a prudent process. You need to document that process because that is a fiduciary activity. Same thing when we think about it from kind of the plan administration side. If you are the CFO, or maybe you're someone in finance and you've signed off on the 5,500, again, that is going to be a fiduciary activity to do so. Nevin, you probably have some thoughts on this, but there's probably some services out there that talk about being 316 or 402A. And again, I'm just spouting off numbers and code sections. But when it comes to things like the administrative side, like signing the 5,500 or that sort of thing, anything that you see in the marketplace that might be confusing as it relates to, well, who's actually the fiduciary, or how does that work when we get to things like the 5,500, the data in the 5,500, or any tips or traps there?
I mean, at a high level, I think there's a lot of interest, particularly when it circles around the topics like litigation. I think people are always interested in sort of like, I don't want to be in the crosshairs for that kind of thing. I don't want to be in that kind of situation. And there is therefore interest. There are different ways these plans can be structured. You mentioned the 316, which is, again, lawyers can't help ourselves, right? We got to throw out code section numbers and things like that. So it's but and a lot of times the 316, that's basically somebody saying, I really don't want to be in charge of all this stuff. And a lot of times it's like, I don't want to be responsible for this kind of stuff. And that's, understandable under the circumstances. But I think, again, the important thing to remember, regardless of your status, is you're going to be you can't not be a fiduciary if you're in a plan sponsor. You're going to have some responsibility. Now you can limit it. Either 316 can limit that, but you're basically delegating off a lot of that responsibility to somebody else. But ultimately, you're still responsible for picking the individuals that you're offloading that responsibility to. And so at some point, you can diminish your responsibility, but you can't eliminate it. And I think that's the most important thing for people to remember. And I would say just ultimately, if you remember that what ERISA is trying to accomplish here is to make sure that everything you do as a plan fiduciary needs to be done in the best interest of plan participants and their beneficiaries. And if you keep that in mind, and that's your North Star for all the decisions that you're asked to make, that's the very best way to sort of stay, safe, if you will. You may not always be safe from getting sued, but you'll be safe in terms of people collecting, if you will, or winning a judgment, that kind of thing. So it's important to be aware of. I can't imagine there's anybody on this call who's not a fiduciary. I'll just make that simple. There may be different degrees in terms of how you play that role, but my guess is you're here today because you either know or are concerned that you might be a plan fiduciary. And I think if you're here, it's probably a pretty good guess.
I think that's probably a fair assumption. And yeah, to your point, it's better to act as though you are wearing that fiduciary hat and follow the prudent process, document what you're doing, and take that path than to think, maybe I'm not. I'll just not do those fiduciary things or not act in the best interest. So I think that makes a ton of sense. You may have people who are on your staff, for example, who are not acting as a fiduciary. And that can be helpful distinctions for some of those folks that are reporting to you or assisting. It can also be very helpful to understand some of the service providers that are saying, wait a second, pushing back, I'm not a fiduciary at all. And I think commonly you see that from record keepers, for example. Within the record keeper world, I would say most of the time, unless they've taken on some additional, what we'll call 316 or discretionary service, for which you're probably paying something extra. This is a broad statement, but most of the time, your record keeper is going to be non-fiduciary in nature. They are acting at your direction to send notices, to prepare a 5500, to do these types of things. And so I think that can be important to make sure we're tracking with who is a fiduciary that you've hired and who is not a fiduciary that you've hired. So that's just one thing to keep in mind on the service provider side. Another party that also says, hey, we're not a fiduciary, are the lawyers. We don't take on fiduciary status either. We take the position that, again, we're acting at your authorization. You're the fiduciary. You're telling us what to do. So again, helpful to just be aware of who is a fiduciary and who is not a fiduciary. So anything else, Nevin, as we've kind of set the table for who is a fiduciary and who is not a fiduciary?
No, I think that's really good. I think a lot of times, unfortunately, people are they fall into these roles, and it isn't always clear what that role actually means. You think you're just here to sort of oversee the 401k plan or maybe oversee the health benefits and things like that. And the word ERISA never even comes up. Because you're really focused on the administrative side of, executing a job that's related to, let's say, HR or employee retention or treasury role kind of thing. But it all comes as part of the package, if you will.
Absolutely. And I know we want to talk a little bit about, okay, well, what are those responsibilities and expand on that a little. Marco, anything before we jump into kind of plan sponsor responsibilities?
Well, it's interesting because I didn't see advisor on that previous slide. And, this is the one thing I'll say. I wrote my first plan 21 years ago-ish. And at that time, I would say an advisor that was willing to be a fiduciary was at the vast minority.
Mm-hmm.
And frankly, it's how we grew our firm. When we popped up to West, we basically said, well, we're not going to allow 2 West to ever not be a fiduciary. So no matter what we did, no matter how we approached a plan, we're a fiduciary, certainly to the investment selection side of things. So that's how we propped us up. But What was interesting back then is that we were the minority. And when we told that story to the marketplace and when we're in front of the next plan, and we explain that to a client, do you want the advisor that's advising you on the plan to have fiduciary responsibilities or not? I would say unanimously, I don't know that I've ever met a plan sponsor that said, no, I would prefer the advisor that's giving me advice to manage other people's money, not to be a fiduciary. It never happened. That conversation never happened. So I would say we're the majority now in the larger plan space. I think most advisors are a fiduciary to the process in the larger plan space. I would say in the small space, it's still maybe 50-50 on who is a fiduciary and who's not. And I'm not going to steal your thunder, but that's why I'm so interested in what's happening in the benefit space, because I think you're in the same 20-year ago space in the benefits that we were and where we are today, where almost all advisors in the bigger plan space are fiduciaries to the process. And I would say in the benefit space, very few are fiduciaries, period. So that's why I want to talk about that and why I'm so interested, because I think it also is going to affect our industry. But yeah, I'll add that.
You are exactly right. You're exactly right. And I think people's awareness of the importance of the role of the fiduciary, this has kind of snuck up on people. And it's kind of crazy. You know, we talk about ERISA and ERISA fiduciary, and people tend to forget that ERISA is both retirement and healthcare. And you know, again, we just kind of go sort of gloss over that kind of thing. But there have been developments recently, and not just litigation, there's been some regulatory developments, and we'll talk about these later, that have actually sort of tried to help make people more aware of that. You know, if you think we had cryptocurrency guidance several years back, well, then like 2 years ago, the Labor Department decided it needed to remind people that those same things that were applied to retirement plans also applied to healthcare plans. And why did they think they needed to tell people that? Because, as we've said, I think people have just sort of forgotten that. But it really is an important thing to keep in mind. I would say, particularly given, you know, my experience, how much time plan sponsors spend worrying about healthcare and healthcare benefits than they do retirement plan. So.
Well, with that, maybe we'll do just a quick reminder of a couple of the responsibilities that plan sponsors have on the retirement plan side, and then move into some of the litigation piece. So again, this is not an exhaustive list of plan sponsor responsibilities. If we were going to do that, we would spend the next 2 or 3 hours going over things that between you and what your service providers do to help you, people like True West as your advisor. But we'll give kind of the high level, hey, these are the things you should be thinking about. Once you know you're a fiduciary, you know that from the first dollar that goes into the plan to the last dollar out, you do have a responsibility to prudently select and monitor service providers. So one of the great things about ERISA is that it does recognize in the spirit of it that, hey, your job is not to become an ERISA expert. Otherwise, you know, Nevin and I wouldn't have jobs. So neither would Marco. So our job is to really become that expert. Your job is to prudently hire someone so that you can continue to do what, you know, your businesses were meant to do. However, you just have to make sure you prudently hire. So in other words, what does that mean? You've gone through a process, you've compared a couple of different options, you've looked at the fees, but again, it's a value-based decision. It's not just based on fees. You also have a job to, when you're making these fiduciary decisions as it relates to, you know, Marco telling you about your investments, or, you know, even as we were talking about like cybersecurity on those things, you need to document your process. It's not about getting to the best outcome, but it is about getting to a process and having an outcome and documenting the steps you took in getting there. And of course, just making sure, as I mentioned a moment ago, that that fee, it's a reasonable fee, not the cheapest fee, but it's reasonable. So we've talked about process. Anything that you do where you're a fiduciary, you need to follow a process. And it's about being objective in your process. It's about making sure you gather all the information that's required. And that doesn't mean just the information that you have available, but that can also extend to other information you should know to go and get to compare and evaluate. And I think that can trip people up as well. So just because you don't have that information, that doesn't mean just stop there. If a reasonable person would say, hey, I actually should check into this a little bit further, then you should do that too, if that's what's reasonable under the circumstances. The final kind of point I'll make there is it doesn't stop with an initial review or an initial selection. All of these things are ongoing in nature, and there's no set rule that says you must do an RFP for your service provider once every 3 years or once every 5 years. The good news is ERISA gives you a lot of flexibility. You could do it whatever is reasonable in light of, hey, if you're doing periodic fee benchmarking and you're getting what you need and the value you need, you don't have to do some big giant RFP. It's about what's consistent and reasonable that makes sense and that's following some sort of reasoned process. So, with that, now that we've talked about, hey, you're a fiduciary, here's your job duties, let's talk about how things have gone wrong over the years, or maybe not necessarily where things have gone wrong, but where there's been a perception that something went wrong, which results in litigation. So, Nevin, question, litigation has been going up or litigation has gone down?
It's been going up. Yeah, it's been going up. And it's crazy. I mean, the types of things people are getting sued for it has evolved a little bit over time. I mean, there's a pretty consistent thread of people getting sued for allegedly paying too much for record keeping or having investment funds in their menu that are too expensive relative to some alternatives they might have. Those are kind of still there. In fact, there was one just last week that brought that kind of thing up. And then we've had the new ones come out. I mean, the forfeiture reallocation suits are the newest of the genre, if you will. And this is where people, they're basically saying you had an opportunity, plan committee, you made a decision on how to reallocate forfeitures. Now we all know what forfeitures are. These are the leftover balances, people who are not 100% vested and they terminated or I guess retired, although if you're retired, usually 100% vested. Anyway, so it's the money that's left behind. And as we all know, the IRS tax law allows you to do one of three things for that. You can either use it to offset plan expenses, you can reallocate it to the remaining participants, or you can offset employer contributions. And that has been the way it's been like forever. Well, the argument that's been made more recently is that if you made a decision, plan committee, to offset employer contributions, well, that wasn't in the best interest of participants. The argument has been that the best interest of participants is to offset plan expenses because the participants are paying that. So how can you, employer, offsetting your contributions, how can that possibly be in the best interest of participants? So there's been, you see the data there, like more than 80. I've lost count of how many these are. So we say 80 plus, and that'll fudge us for at least another couple of weeks. But it's kind of a crazy thing. Now, the other part to note on this is almost all of these have, once they get through the process, have been dismissed before they get to trial. So there's a motion. The plan fiduciaries file a motion to dismiss the suit. They basically argue they haven't made a case. They also say I haven't done anything wrong here. This is what the plan document says I can do. By the way, this is what the IRS law says I can do. And so therefore, I haven't done anything wrong. And most of them have been dismissed. In fact, the Labor Department has most recently come in on 4 separate of these suits. They basically filed a friend of the court, an opinion with the court that says, as the agencies responsible for overseeing all this stuff, we don't think these people did anything wrong either. They did what the law allowed. They did what the plan document provided. The case should be dismissed. So there you have it. Now, having said that, there was a case just last week where a judge kind of looked at all of that same kind of argument and stuff, and he said, basically, look, at the motion to dismiss stage, I think they've made enough of a case. So let's go on to the next level. So it's not settled law yet, but I think what it shows is that the plaintiff's bar continues to look at creative ways to bring class action lawsuits against ERISA plans. Why? Because that famous quote attributed to Willie Sutton, that's where the money is. And so we're going to continue to see that. We had a report come out from Euclid Fiduciary, which is just came out actually like February 9th. And it talked about, you've got 24 data there. This is 2025 data. They've got like 2025, there were 94 excessive fee and imprudent investment lawsuits. That compares to 60, just 66 in 2024 and 48 in 2023. So we've crept up. I think the record was in 2020, believe it or not, in the middle of COVID. One thing COVID didn't slow down was litigation. And in that year, we had 102 of those kind of suits out there. So unfortunately, the pace of litigation does not seem like it's slowing. In fact, as we're getting ready to talk about, there's some new ones.
I was going to say, as we talk about the pace not slowing down, and we move into a new era of litigation, Marco, any thoughts or questions before we move on to kind of the new wave?
Yeah, before we get into that next area, I wanted to ask you guys, and if you have this data, great. If not, I'd be just curious what your thoughts are. 20 years ago, when I feel, I'm just using that as a reference, could be 30, doesn't matter, just a long time ago. When these suits were happening, a lot of them were the bigger plans because that's where the money was. And I think one of you, I think Nevin just said, the attorneys are going to go where the money is, and that's where the big precedents, cases were happening. That's where there was big fees involved and settlements involved. And then lo and behold, there's going to be a copycat, right? They're going to set a precedence, and then all of a sudden, attorneys that maybe aren't as advanced as some of the Schlichters of the world, we're going to start bringing cases against other plans. My question to you is, and just so you understand who's on the call, we serve plans in the 1 million to 500 million space. But in the big scheme of things, these are not mega plans. And however, have we seen the cases come down more into the under $100 million space at an alarming rate, or are we still seeing them in the bigger plans?
Still seeing them in the bigger plans.
Yeah.
It's the way the math works out. The class action attorneys, they usually get 25 to 30% of whatever the settlement amount is, or whatever the litigation amount comes up with. So that tends to veer them towards larger plans which also have more potential plaintiffs. So there is still that trend. Now, the report from Euclid mentions that there's an increasing number being filed against plans that have as low as 250 million in assets. And I think the industry, we've long talked about how this is going to come downstream. There have been, it's still like in the category of maybe a dozen or so cases in the last couple of years where some truly what I would consider to be very modestly sized plans, like 10 million even in assets and less, where some local, a lot of times this is somebody who's coming out of the fallen, what do they call them? The fallen, whatever, the personal injury lawsuits. And they'll see these kind of things out there, and they'll be aware of a situation with an individual in a plan, and they'll basically do kind of a copycat suit kind of thing. And a lot of times those don't end up going like through the full trial process. Sometimes they hold them up, if you will, threaten to do the lawsuit. So there's that. But at some point, your danger here is not necessarily going to be that you're going to get sued by somebody because if you've got a smaller plan. But the reality is the insurance coverage that helps protect against these lawsuits, the rates on that insurance is going up. Everybody's paying more for that. And you're getting asked questions from your property insurers and stuff. I've seen a couple of years ago, they were asking questions, have you ever been named in a suit? Have your participants been reached out to on this? The plaintiff's bar is using social media to find potential plaintiffs, and they're being very successful at it. And that's not necessarily a function of large plan. P.S. If you're a fairly small law firm, don't you think $1 million settlement would feel pretty good in your revenue stream that year? And you can get that from a fairly small plan, basically making the kind of allegations that have been made in these other suits. So it's not the kind of thing I would say, you don't necessarily have to, if you're a smaller plan, you don't have to lay awake at night worrying that you're going to be. The practices are important because what we have found is even among the larger plans, people have been sloppy, at least based on allegations. They've been sloppy about what they do. And it's a good reminder not to be sloppy in what you do, just because you're a small plan, because that puts you at risk, if not from a plaintiff's attorney, from a DOL audit. Um, so again, back to the thing we said earlier, you really want to be doing the right things the right way.
Well, maybe one thing I'll add too, Nevin, I don't know if you have thoughts on this, but it used to be very expensive to file some of these cases because of maybe two things. One, the number of cases that are out there now, it does make it much easier to have these copycats. So I saw a slide not terribly long ago about the number of law firms. So it used to, of course, just be one law firm filing all of them. The number of law firms has increased substantially up to 14 or 15 filing these cases. So one, we've got more law firms doing it, which goes to it moving down market. And then number two, with the use of AI, it's a lot easier to scan and get a lot of this data and information that before would have been very costly to pay an associate rate to put together these lawsuits. And so that's also another contributing factor, making it easier to be able to file these cases.
No, you're exactly right. AI is going to accelerate it even more. We're already seeing signs of that. Um, and there are, to your point, Bonnie, I mean, there are firms that have been extremely active in this field in the last 2 years that had never been in this before. Now, having said all that, Marco's recollection, and Marco, it was like 20 years ago. You're right, when the big 401k accessory, it was 2006, September 11th, 2006. I remember it well. Um, and nobody had ever heard of Schlichter Bogard in 2006. Everybody laughed at them at the time because they had been, primarily a personal injury law firm before that. So yeah, the field of potential plaintiff's attorneys is definitely getting bigger.
With that, and I would encourage people to feel free to drop your own questions in the Q&A, and we'll take those
Yeah,
as we go. I failed to mention that earlier, so don't hesitate to throw your own questions in. Um, you know, we've talked about all of the ERISA litigation and the retirement plan side, but in more recent years, it seems that we've had a new entrant or new topic that's come to light. So, Nevin, care to share what's going on in the healthcare side of the world as it relates to ERISA litigation?
sure. Well, I think everybody knows, everybody's very sensitive on healthcare and healthcare cost. And there's a sense, kind of I would say a kind of a pervasive sense among all the entities who are involved in this, that there's something wrong somewhere, and we need to find out where it is. We saw activity on social media 18 months ago, maybe now almost two years ago, from law firms, as I said earlier, trolling on Facebook, saying, having an icon up of some sort of national employer and saying, hey, are you an employee of so and so? If so, are you covered by their healthcare plan? And if so, you may have a cause of action. Call, whatever. And they give them a website or an email and contact. And so some of us have been watching and waiting for this to sort of happen. And finally, it just happened in 2024. We saw the first instance of it. There have been thus far really only two major lawsuits. These are ERISA fiduciary lawsuits. They are directed at the plan sponsors who offer these healthcare plans. One of them is Wells Fargo. Then the next slide we've got with Johnson and Johnson was the other one. And in both of these cases, the individuals they're basically pointing at their drug costs, and they're saying, as part of this program, I paid this, I was made to pay this for the prescription that I was needed, and I could have paid like tenth of that on retail, even kind of thing. And that's a comparison. The comparison is they cite and use these cases several items in the formularies, what they could have paid and what they did pay, and that kind of thing. And they're basically saying the same kind of allocations you have in some of the or allegations you see in the 401k suits. They're saying, The only thing to explain the fact that I'm paying this crazy amount more than I could have paid on retail is that you're not living up to your duty as a fiduciary. You've not done your job to make sure that the fees that are being paid here are reasonable, and therefore, charging them with a fiduciary breach. Now, the two suits that have been filed in this genre so far they've not gotten past the motion to dismiss. In both cases, the judges kind of looked at the situation and they said, you can't cherry pick. They pointed to instances where these individuals, sure, they paid more for this one drug than they could have in a retail, but there's apparently other drugs there and they paid less than they did elsewhere. And the judges basically said, you got to look at the program as a whole. You can't cherry pick one versus the other. Basically, you haven't proven that you've suffered an injury. And they've dismissed the suits. In fact, the Johnson & Johnson one has been dismissed now twice. One time there was the initial plaintiff was not found to be injured, and they brought in another plaintiff, and they also said, well, he wasn't injured either. So far, the things that you'll see a lot of people talking about in terms of the healthcare fiduciary suits, they really haven't gone anywhere yet, but I would fully expect that they will at some point. They're going to have to figure out kind of how to do it. But I think, again, the important thing here is to remember that ERISA fiduciary responsibility applies to healthcare as well as to the retirement plans. More importantly, and there has been litigation, there has actually been insurance companies suing other insurance companies for a disclosure of the fee information of what those insurers are actually distributing out. There's new legislation Bonnie's going to have. She always has to help me remind it. All I know is CCA 2021.
The Consolidated Appropriations Act.
There you go. And what that did was it basically applied. Y'all remember in retirement world, the 408(b)(2) regulations, fee disclosure regulations that we all struggled with back a decade ago in retirement. Well, in this CCA 2021, that now makes it clear that that same 408(b)(2) disclosure requirement applies to healthcare plans. And all I would say is based on what these, as I said, there has been litigation where insurers, as an employer, have had to sue other insurers to get the information. I don't remember anybody in the retirement space ever having to sue to get fee disclosure. But in healthcare, we're definitely seeing that. And I'm sure if you're all are dealing with your healthcare plans, you might have experienced some of the difficulty in terms of getting some of the actual information from your insurers. But you just need to remember that that is now clearly an ERISA fiduciary responsibility applied to healthcare as well. If you're not getting that kind of information from your providers, I would say you need to be asking why not, because it's out there. And it's going to end up being, as the excessive fee suits in the 401(k) world were initially, it's going to end up being a source of litigation. And you don't want to go to court saying, I have no earthly idea what we're paying. So that's healthcare, but that's not the end of it. What we've been sort of beating around the bush, getting around to, is these new suits. Thank you, Schlichter Bogard, for bringing the suit right before Christmas. A big, nice package. The plaintiff's attorneys have been joking online about something that Santa left them under the tree. And this was a lawsuit. It was filed again. It was for national employers. So it's big employers, but it's with regard to their voluntary benefit programs. I'm not going to recall offhand all of the four, but I remember that United Airlines is one of them. And I remember that because I wrote specifically about the United Airlines case. Maybe we have that on another slide, Bonnie. But 4 national employers so far, only 4 national employers so far. The suits all filed on the same day. This is classic. This is what the Schlichter Bogard firm does. Again, they invented the excessive fee litigation. They invented the university 403(b) suits kind of thing. To your point earlier, Marco, these folks they're trendsetters. They are patient and they file en masse against large national employers. But essentially, and this is the thing that's kind of interesting. I suspect Well, the trend line has been that employers are more and more offering voluntary benefits. So presumably those on the call, you've got these as a part of your offerings or whatever. They've been very popular. Generally speaking, and this is where you end up having some issues, generally speaking, these are not the kind of things that employers are doing or trying to do anything more than sort of making something extra available to their workers. Um, so they're literally are just, it's not something you're necessarily spending a lot of time and energy on. Um, you have a conversation maybe with a benefits broker, maybe somebody you're already doing business with in another context, and they say to you, how would you like to offer your employees access to pet insurance? Or how would you like to offer your employees access to some sort of critical illness backup, something that will operate in addition to whatever you might have in terms of long-term care or hospitalization programs or something like that. So disability insurance is another sort of classic one, something to supplement your current benefit offerings. And as you might imagine, there's some appeal to this in terms of appeal to the employees and the workforce. It's good for you as an employer. You're sort of opening the door and providing something extra to your workers, something that they might perceive as benefit, something you're not having to put any money into, and something that they can do or not do as they choose. It is literally a voluntary benefit, not anything that they have to do, not anything that you necessarily have to do anything with. And I think, generally speaking, most employers have not traditionally given a lot of thought beyond that. It's like, this is something, a nice extra. So here you go. The lawsuits, though, and let me just say this, under certain conditions, the voluntary benefit programs are not ERISA plans. We've been talking all this ERISA fiduciary stuff and how important that is and how it applies. And that's all true. But voluntary benefit programs, there is a safe harbor under which you can operate where it will not be covered by ERISA. And here's the conditions, writ very simply. Employer doesn't put any money into it at all. Employees' participation is completely voluntary. So, like, for instance, no automatic enrollment. Don't automatically enroll people into it, for instance. It's back to the good old days. They got to fill out a form, they got to do all that kind of stuff. A limited employer involved, limited like you're going to facilitate the payroll deductions, like that kind of limited, and like nothing more than that. And this is the most vulnerable area for plan sponsors. No endorsement. So, and the law here is gray. Okay, it is not black and white. But let's say, for instance, that one of the things you decide to do is you hand out a brochure, acknowledging these voluntary benefits, and you put your corporate logo on that piece of paper. Somebody is going to look at that and say that counts as an endorsement. You basically are sanctioning that. Now, the law doesn't preclude that. So again, it's a gray area. But what's important is that you not be seen as endorsing these programs per se. That's the line you got to navigate.
So,
Bonnie, what
Nevin,
am I
let me
missing?
ask you.
Oh, Marco, go for it.
Let me ask you this question. So we've all completed these every year. We have to do annual enrollment. And I get an online link to fill it out. I'm talking for even my own company, and I can't imagine we're any different than all the clients that we serve. Got my logo right there. 2S Advisors offering this package to their employees. I go through it. Right there's the button to click to say all these we offer voluntary benefits. I mean, I guess, and I'm not saying that this is an indictment right away. I'm just saying, but that's kind of what this is saying. That could be viewed, since it's packaged up with everything else, it's not carved out to the side, that could be viewed as an endorsement by our firm for this product, correct?
I'm telling you, somebody will look at it that way.
And
Yes.
and that's the argument they're trying to make, right?
That is the argument
that
they're
brings it
making.
under ERISA.
Yes. Because again, you really want this thing to be kind of an arm's length process. And it kind of runs counter to what you think you're trying to achieve as an employer. You do want to get, some sort of points, if you will, some kind of credit for having made these extra things available to your workers, right? So it runs a little counter to that. And again, it's not a black letter of the law kind of thing. I'll tell you that the kinds of things that are on my short list, and I'll say again, the kinds of things that the plaintiff's bar is looking at is if you present it as part of the company benefits package, so it's like integrated with the rest of the package, using logos, actively recommending or steering people towards particular products, negotiating plan terms or coverage design on employees' behalf. I mean, getting involved with this. And you think about what we said earlier about an ERISA fiduciary responsibility. If you are that involved in it, if you're negotiating fees, if you're negotiating the setup, if you are, let's say, restricting in any way, getting yourself involved in the vendor options and limiting it to a single provider kind of thing, those are the kind of things that suggest that you're actively involved in the development and selection of the plan. Those are the things that make you look like an ERISA fiduciary with regard to these benefits. And crawling outside, if you will, the safe harbor that the law provides for you to sort of keep these programs from being considered an ERISA benefit. Bonnie?
One thing maybe to add too is I think for many reasons, you want to keep these outside of ERISA for many, many reasons. It is possible that the choice could be made, hey, we actually do want these to fall under ERISA. So I think that's really one thing just to keep in mind is, there could be reasons you decide you do want to have it as an ERISA covered benefit, and then you're not concerned about the level of endorsement or having the logo. But once you are into ERISA world, then all of those ERISA duties start to attach. Then you do need to negotiate for reasonable fees and all these other things. So I think it's, you can be ERISA covered. It's okay to use that safe harbor and stay outside of it. You just have to know which side of the fence you're on so that you know what duties and obligations attach to that. And I think that's something important to keep in mind.
That is a great point. At least one of the employers that were sued in this first round, they apparently they had in fact noted their voluntary benefit programs on their 5500. So P.S. If you're not wanting it to be covered by ERISA, you probably shouldn't put it on your form 5500. I'm just saying. So presumably, because it's a large national employer, presumably they intended to do that, and they intended it to be an ERISA plan, and they were fine with that. And again, there's nothing wrong with that, nothing wrong with it at all. But again, what's being alleged in these suits is that they didn't make sure that the fees being paid by participants were reasonable. And we're talking, the kind and the thing we were talking about earlier, the amount of money that is being described as associated with these programs for these employers is tens of millions of dollars. It makes retirement, it's laughable when you compare those kind of fees to retirement plan fees in terms of the amount of money that's out there and that is alleged to be sort of like not being taken care of. So it's a big deal. And I think what that really means, and Bonnie, I'm glad you made this point, is that if you're going to offer these programs, don't have it be an ERISA plan by accident. But if it's an ERISA plan, then do it right and understand all the things we talked about at the entrance of this.
I know we're coming up on time, and I want to maybe tie together a couple of the questions and maybe a concept of kind of how does this impact financial services overall, as well as we come toward the top of the time. I think one question we got is about what is reasonableness. I was on a panel with someone last week, an ERISA attorney who really specializes in health and welfare. And he was commenting that in some of these cases, the broker is receiving between 20 to 40%, and that's what's going to the broker. Mm-hmm. So I think, again, when we think about reasonableness, there is no bright line test on the health and welfare side, nor on the retirement plan side for what is, quote, reasonable. But when you start to do, comparisons, and when you start to look at, especially like on the healthcare side, what would someone who is just paying out of pocket be able to get for this same comparator or something like that? I think those are some of the ways that you're starting to see what becomes reasonable and what becomes, something that's not reasonable. Um, I don't know, Nevin, we could probably go on with some other items, but I think, Marco, one of the things that we've talked about just when we were talking about today's session is what does this do for the landscape overall of financial services firms that are put together of a retirement plan practice and a health and welfare practice, and maybe some other things like, they've got other business lines, and some of those business lines might subsidize one another. And so, longer term, if you start to break down some of the higher fees going to the health and welfare or the insurance side, does that have any long-term impacts or short-term on what does that do to the marketplace overall? And maybe the answer is none, but I think it's interesting to see that there could be some longer-term impacts in the financial services side where there can't be as much subsidization from the health and welfare side to the retirement side. Nevin, Marco, any thoughts on that?
I don't know, Marco?
No, go ahead, Nevin.
No, I think, I think again, one other thing I want to mention about these cases, and it's unusual relative to retirement, the benefit brokers the consultants are being sued also. They are being named as parties. Most of the excessive fee lawsuits that have been filed against retirement plans, sometimes the advisors have been named, sometimes the advisors have rarely have been named as a party. But on these ones, they're like right up in front, and they're all national brokers and things like that. So that is kind of an unusual aspect to it. It could be just making sure they maybe got bigger pockets, but that is something that's also different about these suits and what's going on with them.
The other thing I'll mention, and it kind of goes to one of the questions that just came in too, Bonnie, is that I see an opportunity in the industry. Of course, I'm looking at it through my rose-colored glasses as a fiduciary into the benefit space. Isn't this an opportunity for the firm to pop up and say, we're a fiduciary to this process, and say it differently? Now, the challenge with that is, and that's sour grapes over here. We're doing just fine. We've built a wonderful firm over here because we also have scale. But one of the challenges is the margins go away a little bit. When you start peeling back and making all the fees transparent, it's a little bit harder to drive that profit margin. It just is, because now I have to show every single thing to the client. And we've been doing that for over 16 years. And I know my other friends that are not in fiduciary capacities in the benefit space, still in the retirement plan space. When you don't have to show every single little thing, yeah, you can maybe carve out a little fee there, and it makes things a little bit easier. So the question I have for Bonnie and Nevin, how soon do you think before the all fiduciary firms, if I'll use that term, come into the benefits place and say, hey, come work with me, come work with us. We're never going to take this fee. We're never going to hide fees from you. It's going to be as pure can be. And do you see that as, I think it's out there somewhere. Honestly, I personally haven't seen it. I haven't seen it in action, but I know it's out there. And do you think it's going to gain traction especially if these lawsuits go all the way through?
Go ahead,
Nevin,
Bonnie.
we know of at least one model that's
Yeah.
out there that is their play, right? Is that,
Yeah.
hey, you've got all these other firms that are doing it the wrong way. We're a fiduciary. We're a fiduciary on your retirement plan. We can be a fiduciary the same way over here and help you. But I would say that's not by and large what you see. I think that is the exception right now, not the norm. Nevin, I don't know if you have a different perspective.
No, you're right. It's early days. That they've actually one particular firm has really been kind of counting on the healthcare fiduciary thing to take off. That really hasn't yet. I'm sure they'll quickly pivot to this because it is kind of an extension of the same thing. I think it's inevitable in some ways. To your point, Marco, we talk about it being kind of like it used to be back in the retirement world. I think that's true here too. I think for whatever reason, even though plan sponsors frequently sort of bridge over both of these applications, I think the industries that serve them have been in two different silos. So, healthcare and benefits brokers, if you will, have been like in a completely different world than retirement plan, fiduciary, things like that. I think, there's a lot of talk these days about the convergence of wealth and retirement. I think from a workplace standpoint, the convergence of healthcare and retirement. We know healthcare expenses weigh on retirement savings and retirement preparations. We know that healthcare concerns are one of those big overhanging issues for individuals as they think about stepping off into retirement or think about what they need in order to retire. So yes, considering the sheer dollar value of money that's involved, I can't imagine that you won't see some individuals wanting to step up in this. And there's a comment here in the Q&A about, is there something similar to a 316 fiduciary as it relates to healthcare? And I would say, no, not today. And I would say also, it's going to be different. Healthcare is so transactional. We deal with healthcare like every single year, right? Retirement, you pick a provider, you may ride with them for the next decade. But you don't do that. Well, you may do that with healthcare, but every year is a renegotiation, right? And I think that's going to affect how people approach this business. But yeah, is there going to be somebody who sees some advantage here in terms of negotiating? Trying to figure out healthcare expenses anybody on this call has ever done it? It's a nightmare.
Yeah,
And I
right.
think a lot of times what people end up doing is it's like, so what did we pay last year? And let's see if what we paid, if it's reasonable, next year is reasonable to what we paid last year. Well, that's fine if last year was a good benchmark. But what if last year was wrong or way off course and you're benchmarking to that? And that I think is the environment we're in right now. I think we're sort of holistically benchmarking against last year's experience, which might not be the best benchmark in the world.
So, Bonnie, I want to hit that last question in our last 60 seconds here, but I think it's a good one. There was another question that came up that in the interim, as all this gets worked out, would it be beneficial for a company to go to their broker and say, hey, make sure you put some disclosures out there on these voluntary benefits? And I'll read the one somebody suggested. The voluntary benefits are offered for your convenience and not endorsed by the company. I don't know that we're seeing those disclosures today, but would it be helpful to ask for those?
I think it's certainly helpful to ask for them, but if you're trying to not be ERISA covered on the voluntary benefits and you're trying to stay out of ERISA world, that coupled with these other things you have to do to stay out of ERISA. So it's all facts and circumstances, but that is a helpful idea or step in the right direction to staying out of ERISA world. So
Well, we
hopefully
can go
everyone
on and
found
on
this.
here, Bonnie, but I
Yeah.
think we're at time. Maybe we need to do round two of this next quarter. But you want to talk a little bit about the certificate and then wrap things up?
Yeah, I was going to say thanks everyone for the time and the good
Yeah.
questions. Nevin, thank you so much for joining. Marco, thanks for hosting us. I think the certificate will be available for everyone who attended today. This is for SHRM credit, and then also it will be noted for 2S clients in your fiduciary file. The slides can be available as well. If you have any follow-up questions, don't hesitate to let us know and reach out to your contact at 2S. Thanks again for having us, and we look forward to being back with another topic next quarter.
Thanks, Bonnie. Thanks, Nevin.
Sure thing, Marco. Appreciate it. Everybody have a great day.